Good afternoon, everyone. I believe we just passed the noon hour. Very pleased you could join us. My name is Brent Scorup. I'm a legal fellow at the Robert A. Levy Center for Constitutional Studies at the Cato Institute. And the topic of today's discussion is Tariffs, Emergencies, and Presidential Power, a conversation with Ilya Somin and Walter Olson. And I'm delighted to be joined by Ilya, Professor Somin, and Walter. It's hard to think of more thoughtful and knowledgeable people on all things public policy and constitutional law. And so I'll introduce both of them and then give a little background on today's discussion. Professor Somin is the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute, and he's also professor of law at GMU, and is incidentally my former law professor. He's a prominent book author and a blogger at the Volo Conspiracy. He writes about a variety of issues, including democracy, federalism, and property rights. He has a BA from Amherst College and a JD from Yale Law School. And perhaps most relevant for the discussion today, he is co-counsel in litigation called VOS Selections, Inc. versus Trump. This is a pending lawsuit about tariffs before the U.S. Court of International Trade. My colleague Walter Olson is a senior fellow at the Cato Institute's Robert A. Levy Center for Constitutional Studies. He's well known for his writing on law, public policy, and regulation. He's also a book author, and he was the founder and principal writer of the long-running blog on law called Overlawyered. And he's frequently consulted by public policy officials, regulators, and journalists to discuss law and regulation. And we're very fortunate to have both of them here today. So we're talking about emergency powers, the president, a little bit about the history of how presidents have wielded their emergency powers. But of course, in this context, President Trump's invocation of emergency powers to set and vary tariff rates. And this has resulted in a number of cases, including the one Professor Somin is involved in. Probably most people on watching this know the President Trump has, since coming into office, tried to reshape the executive branch and executive powers, like many presidents before him, but has focused in particular on declaring emergencies and using those emergencies to set and vary tariff rates. Including the so-called Liberation Day tariffs, which impose tariffs on most nations, including targeted tariffs on China that I think presently are up to 145% on most Chinese products. But the stakes are much broader than tariffs, and I expect our discussants will get into that today. So we'll begin with opening statements from Professor Somin and Walter, and then we'll go to some questions I have, and we'll also have time for audience questions. So you can start thinking about those. And if you have a question formulated, you can use Twitter, the hashtag Cato Events, and submit that question. And I will do my best to get to a number of audience questions. Again, that's hashtag Cato Events on Twitter. And we should have time for audience questions. And with that, I will turn over to Professor Somin for an opening statement.
Thank you, Brent, for running this event and Cato for organizing it. In my presentation, I first start off with describing what exactly Trump has done in the area of tariffs. Then I'll describe our case against the tariffs and also briefly note some of the other cases that have been filed. And I'll talk about our arguments for why these tariffs are highly illegal for a whole bunch of different reasons, and also about the grave danger that would exist if Trump is able to get away with this and continue along this path. And obviously, it would be a power then that future presidents could wield as well. Basically, what has happened is that Trump has been trying to use unilateral executive emergency powers to start the biggest trade war since the Great Depression, tariffing almost every country in the world, when raising tariffs to rates that haven't been seen in close to a century or even more. This started in February with the fentanyl tariffs or fentanyl-related tariffs against Mexico, Canada, and China on the pretext that Supposedly, we needed to tariff them because they were allowing fentanyl to flow into the United States. Then it expanded on April 2nd with the so-called Liberation Day tariffs, which imposed 10% tariffs on almost every nation in the world, plus additional so-called reciprocity tariffs, which were imposed in another 57 countries, which are supposedly labeled reciprocity, in reality have nothing to do with anything reciprocal. There are reciprocity tariffs even imposed on countries like Switzerland and Israel, which impose zero tariffs on US goods. So reciprocity is pretty obviously not the real reason for these tariffs. All of these different tariffs are imposed supposedly based on the International Emergency Economic Powers Act of 1977, which allows the president to impose some restrictions on foreign transactions if he first declares a national emergency, and then that emergency must be with respect to, quote, an unusual and extraordinary threat to the American economy or to national security. He has also claimed since then that maybe he'll impose still additional tariffs, just recently saying he might impose an additional 50% tariff on the European Union. He said he might impose tariffs on Apple imported iPhones, and even on foreign movies, which he has labeled a national security threat. So there is no end to the powers that are claimed under the statute. If you buy the administration's interpretation of this law, he can impose any tariffs on any nation in the world in as high an amount as he wants, for as long as he wants, and for virtually any reason. So there's almost no limitations here whatsoever. The Liberty Justice Center and I have filed a lawsuit challenging the Liberation Day tariffs on behalf of 5 U.S. businesses. They're among the many that are severely hurt by these tariffs because they import goods from the countries that are affected. We filed that case in the U.S. Court of International Trade and had oral arguments just about a couple weeks ago. There are also other cases filed against the tariffs. One recently argued also in the Court of International Trade, filed by 12 states, led by the state of Oregon. The state of California has filed a separate case. So have our friends at the Pacific Wiggle Foundation. And there are a number of other cases as well, some in the Court of International Trade, some in other federal courts. In the oral argument in our case and also in the Oregon case, it seemed like the judges were highly skeptical of this claim to virtually unlimited presidential power to impose tariffs under IEEPA. And that skepticism is for good reason, because there's at least 6 different ways in which these tariffs are highly illegal. First, the IEEPA statute does not even mention tariffs at all. That's right, that word isn't mentioned, nor is there a synonym such as imposts or duties or the like. So they're trying to extrapolate the power to impose tariffs from vague language in a statute, giving them the power to regulate certain international transactions. Regulate and tariff are not the same thing. Second, let's assume that there is a power to impose tariffs here. Still, those tariffs can only be imposed in the event of an emergency. And here, there is no such thing. The Liberation Day tariffs, the supposed emergency is the existence of trade deficits between the United States and various other countries. An emergency is a sudden, unexpected crisis. Trade deficits have existed for decades. They're the very opposite of an emergency. They're basically an entirely normal thing, and they're not even actually a problem. Most economists will tell you there's nothing inherently wrong or problematic with trade deficits. I have a huge trade deficit with my local supermarket. I buy a lot of stuff from them. They virtually never buy anything from me. That doesn't mean that there's an emergency or what is also necessary, an extraordinary and unusual threat. It just means that I value what I buy from them more than the money that I pay. And it's more efficient for me to buy things from them than to try to grow all my food myself, as I would otherwise perhaps have to do. And similarly, it is often more efficient and more cost effective for us to buy goods from other countries, which have an advantage in producing them, than to try to produce everything ourselves or to do without those goods entirely. In addition to an emergency, there has to be an unusual and extraordinary threat. There's nothing unusual about trade deficits. They happen all the time. There's nothing extraordinary about them for exactly the same reason. And they're not even a threat because there's no problem as such with just having trade deficits. I would add also that these tariffs have been imposed even on countries with which we don't have a deficit. And as I said before, even on countries that impose no restrictions whatsoever on the import of US goods, and indeed even on places like the Heard Island territory inhabited only by penguins and seals. So there's no real connection between these tariffs and any threat of any kind, much less an extraordinary, unusual one. But let's assume for the moment that perhaps the statute is somehow ambiguous and it's unclear whether it authorizes these tariffs. Then the major questions doctrine comes into play. Over the last several years, the Supreme Court has repeatedly said that when the executive claims that they have delegated to them a power to decide some major economic or political issue, then they have to show that Congress has clearly done so. Ambiguous language is not enough. There has to be clear authorization. Here, there's nothing even remotely resembling any kind of clear authorization. Indeed, as I said before, it's not even clear that this statute authorizes tariffs at all, much less the biggest trade war since the Great Depression. And as for the issue of whether this is a major question, all I have to say is that if this is not a major question, I do not know what is. The Tax Foundation estimates that over the next decade, these IEEPA-related tariffs will impose a tax increase of some $2 trillion on American consumers, plus have all sorts of other major economic effects in damaging the United States and the world economy. This is bigger than anything the Supreme Court has previously said qualifies as a major question. Up until now, the biggest impact of any of the major questions cases involved Biden versus Nebraska, which was the case about President Biden's $400 billion student loan forgiveness program, where the court rightly said this was a major question and there was no congressional authorization for it. I thought that was pretty big, but it seems relatively small and insignificant compared to Trump's gigantic trade war. So if, again, this is the biggest major question probably that any of us have ever seen. But let's assume they somehow get past the major question doctrine and the other issues that I mentioned earlier, and the court rules that there is this kind of authorization to impose whatever tariffs the president wants. Then we get to the issue of non-delegation. The Supreme Court has said that there have to be at least some limits to Congress's ability to delegate its powers to the president. They can't just say, okay, president, you can use these powers however you want at any time for any reason. And the power to impose tariffs and duties is actually a specifically enumerated congressional power in Article 1 of the Constitution. The court standards of what counts as excessive delegation are not exactly a model of propriety to say, well, there has to be an intelligible principle. But if anything is an excessive delegation, this would be, because this is essentially claiming the power to tariff any country at any time for any reason with no judicial review whatsoever. And it's the biggest trade war since the Great Depression, as I've already said. So if there are any meaningful limits on congressional delegation, they should come into play here. Finally, there is a technical legal doctrine known as the constitutional avoidance principle, which says that when there's a challenge to a federal statute and it raises significant constitutional problems, then courts, if possible, should try to interpret the statute in a way that avoids that constitutional problem. Here, there's a pretty obviously big constitutional problem if courts interpret the statute the way the president says it should be. And that problem can easily be avoided if the courts were to give us a win on any of our first four arguments. That tariffs are not authorized, that there's no emergency, that there's no extraordinary unusual threat, or that major questions doctrine applies here. And so the court can easily avoid the big non-delegation problem simply by choosing any of those other four entirely plausible ways of interpreting IEEPA. I will lastly say this. This is an issue, obviously, that's huge in itself, given the magnitude of the trade war that Trump has kicked off and the enormous damage this will do to the US and world economy. But this is also a menace to the economy going forward and to the rule of law as well. If one man, the president, can impose any tariffs he wants, anytime he wants, for virtually any reason, that is totally at odds with the rule of law, which is supposed to be a system of clear rules decided in advance by the legislature, as opposed to the whims of one man doing whatever he wants anytime he feels like it. And from an economic point of view, obviously a system like this can't possibly work because businesses like our clients, consumers, investors, and other actors in the economy, they can't make plans, especially long-term plans, if the tariff schedule can change at a whim anytime the president feels like it. That's, I think, pretty obvious basic economics 101. And so here, economic issues and the rule of law come together. These tariffs are illegal, they're a menace to rule of law, and are also a menace to the American and world economy. Thank you, and I very much look forward to Walter's insightful comments and to the questions and discussion.
Right. Great, thank you, Ilya, thank you, Brent. I would like to talk a little bit about the arguments that are likely to be brought in by the Trump administration in defending these suits, as well outlined by our friend, Professor Mike McConnell of Stanford the other day at the Volokh conspiracy, which is your one-stop shop for all of the arguments both for and against this litigation. And also to talk both about Cato's longstanding interest in emergency powers of the presidency, which I can tell you we have been trying to restrain. I did a search and there were hundreds and hundreds. One of the first that I noticed was an article we printed in 1987 by Robert Hicks and a co-author, saying that the dangerous emergency powers that were on the books then endangered the economy and property rights. It all seems like endless deja vu. We have been working on this pretty much continuously ever since. And I'd like to quote briefly from the Cato Handbook for Policymakers, the 2022 edition, the most recent, where Cato's Vice President Jean Healey did a chapter on emergency powers, presidential emergency powers, and said a couple of interesting things. First, he and just as preface, one of the things that makes this complicated is that rather than there being a single law about emergencies, there are in fact several. We've been talking about IEEPA. More often, we find ourselves talking about the National Emergencies Act, but there are a lot of others too. And Jean writes specifically that Congress should amend IEEPA, the International Emergency Economic Powers Act, to first provide that new IEEPA declarations expire within 90 days without affirmative authorization by Congress. That would already be changing the politics of this considerably if they had done that. Require yearly congressional reapproval of ongoing IEEPA programs. 3, prohibit the use of IEEPA authority to impose tariffs or import quotas. Again, there were people arguing for that power, but most of us believed that the power was not there. But make it explicit. Had they done that, we wouldn't be here today. Require a warrant based on probable cause before Americans' assets can be frozen. Again, other dangerous powers that we haven't seen yet under Trump's exercise here. And require meaningful due process for U.S. persons targeted by IEEPA sanctions. Again, sanctions and tariffs are two different things, but if there were ever a good case for due process, you might think that some of the incredibly random damage suffered by individual business owners just because their product is being miscategorized or misapplied by Washington might be part of that. Now, Healy, and I'm not going to quote too much more, but he says that America's Constitution is exceptional in part because our framers thought a lot about the dangers of emergency powers. It was exactly the kind of thing that the British king had used to do things like suspend habeas corpus or take other extraordinary measures. And so the Constitution grants only sparse emergency powers to the presidency and vests them in Congress. It says that Congress must approve with habeas corpus, with the suppression of insurrections, repelling of invasions. So we have that structure to start with. And I think for the courts to use as a guide in proceeding on this, the presidential use of emergency power is exceptional. It is subject to narrowly constrained congressional approval. Now, at this point, someone in the audience is probably throwing up their hands and saying, but this Congress doesn't object. Not only have they missed decades of chances to narrow the presidential powers or the definitions of emergency, but right now they would not stick up for their own powers if we asked them. And that is not just a matter of assembling the 2/3 majority that would be needed to override an emergency declaration under the National Emergencies Act. They just aren't standing up at all. And when people raise that objection, I think back to a great jurist I once had a chance to talk to about a very similar separation of powers thing, which is what happens when Congress, I think it was Congress, refuses to defend its independent authority and instead goes along with the executive. And he said, the branches are not authorized to conspire against the people. I've always remembered that sort of pithy phrasing. That separation of powers is put in there to prevent certain types of collusion between the branches of the government in order to accomplish things the founders didn't think should be accomplished, at least not without more friction. Now, we've got some of those broader questions about emergency that were well explored by Ilya as far as whether the practical facts are there for it. But we also have this fairly complicated statutory background. And if you have followed the debate on places like social media, you may have seen defenders of the Trump administration's power in this area say things like, well, Nixon did this, Nixon imposed tariffs, and the court upheld it. And that is what Professor Mike McConnell analyzes in much of his interesting piece. And although it's too complicated for me really to do justice to it, I'd like to at least pass along a couple of the highlights. I should say that Professor McConnell himself believes that the tariffs should be struck down, and I believe as amicus in one of them, but wants to do justice to the strongest parts of the case for the tariffs, in part because he wants us to be prepared for these arguments, and in part because it's always a good idea to do justice to the strongest parts. So let's talk about that Nixon experience. It happened under not IEEPA, but a predecessor statute called the Trading with the Enemy Act, which has kind of a ring all from its title of having been a different law. Trading with the enemy was a different issue. It is not very closely related to tariffs against Switzerland or against Penguin Island. But that's the authority that Nixon was using. And the challenge to his use of it never went to the Supreme Court. It went to a customs court, which was a predecessor of what is now the Federal Circuit. And so you've got a predecessor statute and a predecessor court. Right there, you have it's sort of receded into the past. You also have an era in which views of executive power were different in a number of different ways. But how did it work in the case of Nixon? Well, people challenged it as excessive use of the powers that Congress had delegated to him. And it must be said that Nixon was citing things like the balance of trade. Economists scoffed then as they scoff now, but nonetheless, Nixon's motivation therefore mapped onto one of the, by my count, 37 different motivations that Trump has cited. So in that sense, they're similar. So it got challenged. And in the meantime, Congress, a more responsible Congress in that day than in this, went back and revisited the power. And they didn't want to take all the power away from the president. They wanted to cabinet. They wanted to put in procedures and thresholds and opportunities for Congress to do oversight. And so they enacted a new statute that would effectively bless some uses of this, but not the full scope of the things that Nixon did. So when it reached that customs court, they basically had two things to decide. One, whether to allow the new congressional law to go, this was not a question. Yes, Nixon's more limited power under the new law was not really an issue. The question was, would they go back and knock out things that he had done under his view of the old one? And the Supreme Court did what it does fairly often, I understand, through history, which is decline to upset an apple cart of action already taken, so long as it's clear that from now on, the actor, the president in this case, has to follow the rules. So that's what they did. They did not overturn his interpretation of the older one. And you can see some of this, in things like, I believe, the government's improper restrictions on evictions during COVID. The court made quite clear, I believe, when that came up, that it could not do so going forward, but it was not going to go create a remedy for all the landlords who had suffered in the past. It was going to take effectively prospective action. So again, this is not the courts behaving very unusually, but the Trump administration wants us to believe that that's good precedent, establishing forever that all presidents have the sort of power that Nixon thought that he had. And I am with Professor McConnell in saying that once you understand the sequence there, you are not, in fact, going to see that as adequate justification. Now, let me just move on, because part of this is dry statutory analysis. A lot of it is mood music. And the mood music in this case is we have about 4 different areas in which judges often give a little more deference to the executive branch than usual. One of them is tax issues, although it's only fair to note that they're usually giving tax deference to Congress rather than to an executive branch. On economic policy, they usually give more leeway. On foreign policy, they certainly give more leeway, and Trump has definitely been pushing that argument, that he is using these tariffs not just to change the balance of trade, but in order to beat up and bully other foreign countries, and he must have a right to do that under the Constitution because the president's in charge of diplomacy. And finally, national security. We all laughed at the idea that the foreign production of movies was a threat to national security. Nonetheless, he's using that. Let me just say, they sound like impressive mood music sometimes until you realize how often the courts, once they identify an illegality or an overstepping of statutory authority or an overstepping of constitutional authority, will in fact ignore all of those semi-presumptions and march forward and protect rights. You can see that in cases from, let me just pick one from the last week. In Trump's penalty orders against law firms, one of the toughest nuts to crack for the law firm defendants has been the revocation of security clearances, because everyone assumed that it would be very touchy to ask courts to approach that, because the president, that's pretty close to core executive power. But Judge Bates, in the Jenner and Block order, the permanent injunction that he just issued, did something that's kind of beautiful, which he says, let's take that seriously, since it would be dangerous for courts to just endlessly second-guess security clearances. Trump himself, in the operation of his law firm orders, has consecutively said that it is important for the national security to ban lawyers from firm X from having security clearances, and then after they agreed to do him favors by doing pro bono for his friends, no more ban on that. They are free to go ahead and have their security clearances, which he says shows how protectual it is. It shows how by the president's own estimation, there was never any real demonstrated security risk. And don't be surprised if that happens again. I can only return to one of the most inspiring and important cases in our constitutional law, which is the Youngstown sheeting tube, the steel seizure case in 1952. It had been widely assumed that the president's inherent national security power allowed him to do many, many things. The Korean War was actually going on, a hot war, when President Harry Truman seized the steel mills. And the court pulled itself together, even though it was entirely appointed by presidents from Truman's party and was considered very favorable to the New Deal. They said no. Even though there is very real national security here, it doesn't mean a president can simply do anything. Let's see those days again, please. Thanks.
Thank you for that, Walter. And I'll turn over to Professor Somin for a few minutes of response and thoughts that something Walter may have said. And I want to remind viewers again, if you have questions, please use the hashtag K2Events. Again, hashtag K2Events on Twitter. Professor Somin.
So I don't disagree with most of what Walter said. I just like to comment on just a couple of points that he raised. One is the issue of the litigation from the Nixon era, which culminated in the Yoshida case, which did uphold the imposition of tariffs based on the Trading with the Enemies Act, which is sort of the predecessor statute to IEEPA. This case is discussed at great length in our briefs and other filings in the case, and was discussed at great length in the oral arguments. Here, I'll just mention a couple points. One, as Walter mentioned, this was not a case about IEEPA. It was a case based on the predecessor statute. IEEPA was enacted to replace that statute in part because Congress at that time thought presidents had abused emergency powers, so it should not be presumed that whatever powers exist under the Trading with the Enemies Act necessarily carry over into IEEPA. But even if the Yoshida case is somehow good precedent under IEEPA as well, it does not give Trump the kind of virtually unlimited powers to impose tariffs that he claims here. Indeed, the Yoshida case specifically says that an unlimited power to impose tariffs would be unconstitutional and illegal, and they upheld Nixon's use of the tariffs only because it was working within the tariff schedule previously imposed by Congress, and there were a number of other constraints as well that we talk about in our briefs, and I'm happy to talk about in questions. I would add also that Yoshida was decided long before the major questions doctrine, and I think if the major questions doctrine was in effect and used by courts back in 1975, Yoshida itself might have been decided differently. The second issue, the issue of deference to the president on national security and the like. I think such deference has gone too far in a variety of different cases, but here we're not even talking about an independent presidential power. We're talking about a power that the Constitution, specifically in the text, allocates to Congress. So it makes no sense to defer to the president here in a situation where the evidence strongly suggests that Congress didn't even delegate this authority to him in the first place. And if they did, it would raise a massive non-delegation problem of the kind that I described earlier. Finally, Walter is absolutely right. It would be good if Congress were to rein in presidential emergency powers, both with respect to IEEPA and with respect to the National Emergencies Act of 1976 more generally. We could hold a whole other forum on that, and we have actually in the past. Maybe we need another one. But here, as bad as Congress's dereliction is, we should not allow Trump to make things even worse by claiming these vast powers that go beyond even what Congress, has allowed to happen. At the very least, the kind of power he claims here, he needs a much more clear and explicit delegation from Congress in order to make a plausible argument for it. And even then, there would be constitutional problems. And with that, I conclude for now, but I very much look forward to the discussions and questions.
And I'm happy to go ahead with the questions and discussions. I'll throw in one more case just because, as I said, emergency powers are pervasive. some of the most interesting litigation that we've seen was on the COVID orders. And as you remember, a number of the different orders that came down from the federal government responding to the COVID epidemic were couched as emergency orders. And the courts brought a skeptical eye to that. In particular, when they reviewed them, they upheld an order that was fairly narrowly addressed to healthcare workers and where the federal interest and the infringement of rights was at one side of the spectrum. And then they struck down OSHA's attempt to do a similar thing for the private workplace generally. And part of that, hearkening back to a theme that we've heard a couple of times, was that the president, or the OSHA in this case, was not writing on a blank slate. There were in fact two tracks. There was the accepted notice and comment manner of regulation, which the court was generally quite deferential to rules developed that way. And then there was the attempt to bypass it and do it under a claimed emergency while skipping the rationality controls, as well as some of the chances to get judicial review. And you see the same thing on the question of whether the president is trying to use a well-defined congressional authority of the sort that Ilya was just mentioning was eventually in place for Nixon and is still in place now with respect to things, or is trying to obtain powers that Congress was not trying to give him or the agency or whatever. I think that bodes well because, again, Trump is impatient with working through the ordinary procedures on things, and that has cost him on a wide range of different challenges. It could cost him here too.
That the OSHA vaccination mandate to which Walter refers, I've written an article about this actually for the Cato Supreme Court review about those cases. Technically, those cases, the Biden administration was not trying to use emergency powers. They were trying to use the OSHA Act sort of normal procedures, which potentially can be used even when there isn't an emergency. And they got struck down on the broader one, which was claiming vastly sweeping powers. They did cite the COVID emergency when it comes to the loan forgiveness case that I mentioned earlier. And the court rightly struck it down and ruled that it was a major question. There's a somewhat similar story with respect to the eviction moratorium, which also technically used the statute, which is in effect all the time and not just during an emergency, the Public Health Service Act of 1944, but atmospherically, they were using the COVID emergency to try to justify that, first under Trump, who first issued the eviction moratorium policy, and then Biden continued it, and the court struck that down as well. I would merely add that at least the COVID emergency, the COVID situation really was an emergency. It was a sudden crisis. 1 million Americans died of COVID. At least it wasn't a completely fake and bogus emergency like Trump's assertion that trade deficits qualify as such. But even then, with the genuine emergency of COVID, courts often struck down emergency measures that went beyond the actually granted emergency powers. And I think when it comes to a completely fake and bogus emergency, judicial review should be even stronger.
All right, thank you for that. And now we'll go to the question time. I've got a few, and we have some audience questions coming in. But I just on the note of Professor Somin, I think you said fake and bogus emergency. Yeah, on that note, as you know, presidents have called all kinds of things emergencies. I mean, some many are somewhat dubious. In preparing for this, I looked up some emergency declarations. President Bush declared an emergency about violence in Cote d'Ivoire. It's a fairly small African country. Said that's an extraordinary national emergency, and you have many like that. And generally, courts are very deferential. They don't like to be second guessing, particularly presidents, their declarations of emergency. So, how would you expect a court to weigh these competing issues? Looking to try to look at whether determine whether this is a real emergency, and the fact that under law, Congress gives broad delegations to the president to declare an emergency, and generally to date, courts have been very reluctant to assess whether it's fake and bogus or a legitimate one. We'll go to Professor Somin first.
Yeah, so it's a good question. I'll answer it in two ways. First, I would reemphasize that IEEPA requires not just an emergency, but also an extraordinary and unusual threat to the economy or national security. And while there is some precedent interpreting emergency broadly, or at least deferring to a president on that, there's no such similar body of precedent saying a president can just call anything he wants an extraordinary and unusual threat. And indeed, if you defer an emergency and you also defer an extraordinary unusual threat, to the extent that anytime the president says there's an emergency, he can automatically claim there's an extraordinary and unusual threat as well, that would make the extraordinary and unusual threat provision superfluous, and that violates a basic rule of legal interpretation, which is the courts are not supposed to interpret laws in such a way as to render parts of them superfluous. But even on emergency, while I think there have been some past abuses, at least all or nearly all the cases where an emergency was declared really was in response to some kind of sudden, unexpected crisis. Whereas here we have trade deficits that have gone on for decades. They're the total opposite of a sudden, unexpected crisis. That violence in Cote d'Ivoire, you can argue about whether it was significant enough for the US to be an emergency for us, but at least it was a sudden upsurge of violence, not something that had been going on for decades. And the same thing can be said, for a variety of other cases. I would add that while there's precedent for bogus emergency declarations, albeit dubious precedent, there is no precedent, at least in the last century or more, for using a declaration of emergencies to claim such vast and sweeping powers, starting the biggest trade war since the Great Depression, imposing $2 trillion worth of tax increases, and so on. So those other precedents, such as they are, I don't think they can plausibly be stretched to encompass this situation, and they certainly can't justify ignoring the separate requirement that there must be an extraordinary and unusual threat and not just an emergency.
Walter, I don't know if you have thoughts on this question of these balancing interests that courts face.
Well, there is no doubt that courts are reluctant to second-guess presidential declarations of emergency. I agree with Ilya that if there were ever going to be an instance where they stood up and carried out their responsibilities of holding the president to legality, the situation here is so extreme. And again, to revert to an argument that I raised earlier, when there's strong evidence the president himself doesn't believe his own rationale, that when his behavior belies the idea that he takes this emergency seriously, that ought to be the time when the court feels bold enough to step in. Otherwise, it's a dead letter, and the president has all power. I can't believe that courts actually see that as an acceptable endgame in the separation of powers.
One of the possible rationale for deference is, well, the president, or at least his advisors, have specialized expertise that's not available to the courts. But if you're going to go that route, you want to make sure that this really is a policy that is based on reliance on some kind of specialized expertise, as opposed to that expertise just being used as a pretext for something the president wants to do for other reasons. That's what happened with Biden and loan forgiveness. The loan forgiveness had nothing really to do with COVID or any specialized technical expertise. It was just trying to achieve a longstanding objective of the Democratic Party that they weren't able to push through Congress. Similarly here, this is an attempt to impose a massive longstanding agenda that certain types of protectionist national conservatives have long had, and it has nothing to do with any kind of specialized technical expertise that the president has access to, and the rest of us do not.
So my next question is, I guess, a bigger picture question about, the president has signed, I think, a record number of executive orders and declared a number of emergencies. But this issue of tariffs and his sensible emergency powers seems to have struck a nerve It's frequently front page news. There's a lot of litigation about it. Why? But at its core, it's I wouldn't say a dry, but a fairly detailed argument about statutory interpretation and deference to the executive. But why is this issue really gotten so much public attention and drawn so much litigation? Walter,
I think
first, if you want to go first.
Yeah. The importance of the tariff moves as far as impact on many groups of Americans in many ways is hard to compare with anything that comes before. Whether you're interested in the auto industry, whether you're interested in home building and lumber, whether you are interested in bilateral relations with any of these countries, from Canada to the farthest parts of the world, all of those groups, within a matter of a few weeks, were put onto a kind of crisis footing. The possibility that a business plan formed on existing conditions would become grossly unprofitable because of the changes got everyone's attention. You don't have to be in the toy and doll business. You don't have to be in the grocery business wondering about avocados, because it's hitting everyone. And from Trump's standpoint, this was also, aside from his beliefs about it supposedly benefiting the state of the economy, this was a uniquely powerful assertion of authority, because, as he himself has said in almost these terms, it means that every country in the world and every company in the world economy has come around trying to butter him up, trying to offer favors, trying to get on his good side. Nothing else in his toolkit has accomplished that. So he clings to it more. It is, for the same reasons, threatening to the rule of law, even when companies manage to get on his good side, as we've just seen with Apple, which managed to get on his good side for a while. And then some say because Tim Cook didn't show up in the Middle East for a certain dog and pony show, Trump turned against him. Again, this is power that is felt as arbitrary power, even if you believe that you can economically survive it.
Yeah, I think Walter is right. This has attracted attention, one, because of its enormous scale, which matters both legally and politically, but also because this raises prices for almost everybody in American society and the economy. You will recall that the Democrats lost the election in large part because people didn't like the price increases that had happened. This will impose huge price increases on a vast range of goods, that almost all Americans consume. And so it matters for that reason as well. Though I will note that Trump has claimed almost equally specious and sweeping power by claiming that illegal migration qualifies as invasion, thereby granting him all sorts of authorities. I've written about that, and we could do a whole other forum on that. As yet, the practical effect of that has not been quite as great as that of the tariffs, but it is very large, it is abusive, and I oppose that too, and I have writings on that subject, and am filing an amicus brief in one of the cases raising that.
Thank you. And a word about emergency powers, just for the audience. Strictly speaking, there are no emergency powers. The Constitution doesn't use that phrase. And unlike many other national constitutions and some state constitutions, there's not emergency power. It's more of a casual term for what the president and Congress and courts believe the government could do during a real perceived crisis. But yeah, strictly speaking, there is not emergency power, only the enumerated powers in the Constitution. So with that aside, speaking of emergency powers, I think you both mentioned IEEPA, which is the core statute, emergency statute that the president cites and many other presidents have cited, and the predecessor, Trading with the Enemy Act, which are fairly similar. Only one is used in wartime and one is used not in wartime. Both these laws have been used by presidents for decades for immense claims of authority. FDR, for instance, used the Trading with the Enemies Act to compel Americans to turn over their gold to banks, to regulate consumer credit for the first time nationally. This was during peacetime, but during the Depression. And in other presidents, you mentioned Nixon used Trading with the Enemy Act to impose tariffs. LBJ used the Trading with the Enemy Act. Similarly, however, and Professor Somin, you mentioned in your brief, I believe you made a non-delegation argument. As you know, that the non-delegation doctrine argument has more or less been a dead letter for decades. Is this the case that forces courts to once again bring some rigorous scrutiny and some, be persuaded by the non-delegation arguments that you and others have made? I should add, Cato filed an amicus brief in a related case. We make many arguments similar to yours, but so this is a question I wrestled with myself. Professor Somin.
Yes, presidents. There have definitely been abuses under other presidents, including some of the ones you mentioned, but no other president has ever used IEEPA to impose tariffs in the almost 50 years that statute has existed. So that's actually a new innovation of Trump's. Then there is the broader issue of the non-delegation argument. You asked, well, would this be the case that will sort of revive non-delegation? I think maybe, though I think it's quite likely that we could win on just one of our other 5 arguments. And if we win on one of those other arguments, then the courts need never reach non-delegation. Indeed, one reason why they might want to give us the victory on one of those other claims is so they don't have to deal with the sort of the morass of non-delegation doctrine. However, while it is certainly true that the Supreme Court has been relatively lax in recent decades with respect to its standards for non-delegation, they have always said that there have to be some limits, the so-called intelligible principle rule. And 5 conservative Supreme Court justices have said that non-delegation doctrine should be beefed up. So potentially this could be the case to do it. Even without any beefing up, if you think there have to be any limits to delegation at all, and all current Supreme Court justices have said there have to be at least some, then you have to impose them in a case like this, where the president is claiming essentially unlimited, unreviewable power to impose any tariffs he wants in any amount. If this case were to reach the Supreme Court and they decided it based on non-delegation, 2 big ifs, this would be the biggest claim delegation that has ever come before the court since the Schechter-Poultry case all the way back in 1935, which related to the National Recovery Act, enacted 2 years earlier, which had given the president the power to impose wage and price controls and other rules for virtually every part of the non-agricultural economy. The Supreme Court said that was delegation run riot and it was excessive. This is much the same thing. Schechter-Poultry is still on the books. A delegation as sweeping as Schechter-Poultry would still be struck down. And this is the first delegation that presidents have claimed since that time that is comparably sweeping. So my hope and perhaps my expectation is that this case is more likely to be decided on one of the other issues than on the non-delegation one. But if it comes down to non-delegation, if the Supreme Court or other courts want to impose any limits on delegation at all, they got to do it here. Or they can say, as a few of my law professor colleagues do say, there are no limits to delegation whatsoever. That's a logically consistent position, but it has, dire implications.
Yeah. Ilya mentioned the constitutional avoidance doctrine, and just analyzing the way the court has tended to approach cases, especially challenges to Trump policies. We know that they look for procedural off-ramps, and those are a little less obvious in this case, how they could dodge it. And they also look for ways of splitting the difference and being narrow. Again, not so easy to do in this case because most of the theories we've been talking about don't cut the tariffs by half. They eliminate the authority, but that gets you to things that knock it out on constitutional grounds and things that knock it out by taking a hard look at the statute. And I think, as I think Ilya also does, that they are much more likely in terms of practical politics to um, read the statute closely and find that it doesn't support the power, and perhaps announce in their decision that Congress can come back and pass a reworded authorization giving Trump more power and perhaps all of this power. I think we all realize that if that were thrown in Congress's lap, that in practice, the farmers would have their say better and the home builders would have their say better. And they would not, in fact, authorize all this stuff. They feel they have to because Trump is their leader. But if Congress were drafting an authorization from scratch, knowing what it knows now, it's hard for me to believe that even this subservient Congress would give Trump all that power.
All right, thank you. I should add, the question I had was also one from the audience, and I'll go to the audience questions again. And again, if you're in the audience, you can use hashtag Cato Events on Twitter. But a question from a couple people asked this: Is a tariff on a specific firm constitutional? And one opined it would seem to be an unconstitutional taking of property. So is a tariff on a specific firm constitutional? Perhaps Professor Somin first.
Yeah, that's a good question. I should note that I'm actually a takings scholar, and I've written books and articles about takings, frankly, more than about tariffs. So to take the takings question first, so to speak, there is a long-standing doctrine which says that taxes are, and tariffs are a kind of tax, are not takings. There are some scholars like Richard Epstein who dispute that and say many taxes should be considered takings. I think it's very unlikely that the Supreme Court will endorse that position anytime soon. Maybe a tariff on a specific company is problematic for other reasons, perhaps would be considered a bill of attainder, though my understanding of bills of attainder, Walter can correct me if I'm wrong because I'm not a bill of attainder expert, but my understanding is that primarily applies to criminal penalties, so maybe a tariff wouldn't work that way. However, I would note that under the Trump administration's interpretation of IEEPA, they could impose a tariff on a specific company, as Trump actually threatened to do recently in the case of Apple. All Trump has to do is say, well, it's a national emergency, that too many iPhones are produced outside the United States rather than within it. And it's extraordinary, and that automatically makes it an extraordinary unusual threat as well. And what's the solution? Well, we tariff Apple because Apple is a particularly egregious offender of producing too many iPhones abroad and not enough in the United States. And all of that sounds absurd, but it would be permissible under the administration's interpretation of IEEPA, where all of these determinations about national emergency, extraordinary unusual threat, and so on are delegated to the executive and completely unreviewable.
Yeah, bill of attainder arguments have been not popular with courts, including in some recent instances, such as the law firm penalty orders, where the popular commentary has said, gee, that looks like a bill of attainder, and judges have typically not gone there. I would say, in addition, as far as why such a challenge might not work if he tariffs a particular firm, IEEPA has all of these things about sanctions, and sanctions, of course, are often firm-specific, and they do often reflect the idea that in conducting foreign policy, you might want to restrict one particular firm that has shown a tendency to trade with the enemy or whatever. So again, have to see the arguments, but it's not at all impossible to think that Trump is going to do that and get away with it.
Get away with it if his interpretation of this law is accepted. If it's not, there still could be firm-specific sanctions of some kinds and have been in the past, but there wouldn't be the sweeping power to impose sanctions on any firm for any reason, anytime he wants.
Right.
Thank you. And this will probably be our last question. If the Supreme Court were to rule against the Trump administration, I suppose in your case, Professor Somin, or the related ones, it's always a hazard guess how a court will rule, but how would a court craft an opinion that neither strips the executive of emergency powers that Congress intended to delegate, nor essentially rewrite the law? And I guess, a broader question, do you think this is different in kind, not merely degree, and that the courts will step out and bring some restraint to these broad claims of executive power.
Yeah, so I guess
Wally.
I'm sorry. Go ahead, Wally.
Yeah. Well, again, much as I wish we would get a Youngstown Steel dramatic ruling for the ages out of this, I don't think that's what the Supreme Court wants to give us. I think they want to make it look as if it's a narrow ruling, and even if it invalidates the tariffs, not look as if it is deciding anything all that huge or permanent about separation of powers. That's their preference. Whether they actually wind up doing that, I don't know.
And
So
Professor
as I
Somin,
said,
give you a last word.
Sure. As I said before, there's 6 different ways they can rule in our favor, some of which would have broader implications and others. Obviously, the broadest would be a non-delegation ruling, but all of the others would still have very important implications because the power that Trump is claiming under IEEPA is so sweeping and unlimited that any of these 6 pads would knock out that power, at least to a very large extent. And that would have significant implications going forward, even if it was purely based on statutory language and not on constitutional principles, or if it was based on the major questions doctrine. For example, when I teach law students, a lot of the cases that we assign, they're important not for the immediate facts of the case, which are important to the parties, but probably not usually important to society as a whole, but rather those cases are significant because of precedents they set. Conversely, there is the occasional case like Bush versus Gore, whose precedential value is not that significant, but which was really important for the immediate circumstance. It determined, who got to be president at that particular time. This case is important for both reasons. It will, even if it's decided purely on statutory grounds, set an important precedent. And also it's important in and of itself because of the enormous scale of these so-called Liberation Day tariffs. So there's no way, I think, to avoid creating a case which will be significant here. It's just a matter of how significant it's going to be.
All right. With that, we'll wrap up. I want to thank Professor Somin and Walter for participating in this very important discussion, and I want to thank the audience for joining us for an hour. You can find more information from Cato Scholars at cato.org. Thank you for joining us.